Hello, I want a loan of 1 crore rupees to run a restaurant business. So that's why I'm here. Sure, let's first finish up with the documentation, and I would require all the details of the business that you want to run and everything so that the bank can disburse the loan to you. Okay, and your ID proof and everything. And also, then we'll have a meeting with the branch manager as well.
One eternity later.
Hello, I wanted to schedule a meeting with the branch manager. Actually, I took a loan from your bank 1 year ago and I couldn't pay my debts off. Like, I only have 5 lakh rupees left in my account and the entire company has gone insolvent. So I can't pay back the 1 CR. Okay, I get it. That's some serious problem. So, which means you have gone insolvent. So, we would be required to approach the court in that case. I'll schedule a meeting with branch manager, but just to inform you that yes, we'll take this to the court and CIRP process will start so that you can get rid of this bankruptcy situation and you can pay back your financial creditor, which is us, of course, the bank. So imagine the situation where a company or an individual gets insolvent and they are not able to pay back their creditors any debt that they have taken from them. So will it be the end? Or can the company be revived? The solution part. So this is what we are going to discuss here. That is the Insolvency and Bankruptcy Code of 2016, followed by important provisions, amendments, pura CIRP ka process and landmark cases explained in very easy way. So let's begin. So let's start with the concept of insolvency and bankruptcy. Okay. So, first of all, what is insolvency? See, insolvency and bankruptcy are totally different concepts, part of the same structure. So, insolvency means a financial condition where a person or a company, okay, cannot pay debts when due or liabilities exceed assets. So, basically, it's a condition, financial condition of a person or a company. Okay, so an individual can go insolvent or a company can also go insolvent. Fine. For example, a company owes banks 100 crores but has assets worth only 60 crore. That is, the company is facing huge losses. This is the financial condition of a company. So it takes help of the courts to help it recover its debts. Okay, so that its creditors' rights should not be violated, because a company owes a lot to its financial and operational creditors. We'll get to these terms as well. So if there are creditors, there are debtors. Okay, debtors, the person who takes loan, creditors are the ones who gives loan. So a company requires loans at a lot of point, okay, to buy materials or the capital needed and everything. Like for example, if I'm taking a capital from bank to run a restaurant, so in that particular case, bank will be my creditor, I'll be a debtor. So it's my responsibility to pay the debt off as well. But what if my financial condition doesn't support me? Then to whom will I go? That is what is dealt under Insolvency and Bankruptcy Code. So here, bankruptcy. Now, bankruptcy means legal status declared after insolvency proceedings. So, bankruptcy is a legal process. What is it? It is a legal process to help you tackle insolvency ka condition. Okay, usually leading to liquidation of assets. If after sab haath pair maar ke, if after trying everything, if still you can't do anything about it, you can't find investors who will take your company and grow it and invest more and again run the company from fresh, you didn't get anything. In that particular case, the assets will be liquidated, it will be sold off and so, okay, or structured repayment plan. So either the bankruptcy is a legal process which will either lead to liquidation or it will lead to structured repayment plan, okay, where you will find new investors to invest in your company and again rerun the company nicely, okay, so that you can pay your creditors and everyone. Understood the concept of insolvency and bankruptcy? Now, what is Insolvency and Bankruptcy Code of 2016? 2016 mein a code came which is Insolvency and Bankruptcy Code. It is India's consolidated law governing insolvency resolution and bankruptcy for corporate persons, that is companies, LLPs, okay, partnership firms and so, fine, and then individuals. Okay, so in sabke liye Insolvency and Bankruptcy Code gives a one-stop destination to resolve your financial condition. So here, it replaced a fragmented system that earlier operated under multiple laws. 2016 is the year when this code was passed. Okay, but before that, how companies or individuals used to tackle insolvency? Okay, because there was no such code. So these were the regulations or laws that were applicable. Companies Act, Sikh Industrial Companies Act, SARFAESI Act. Debt Recovery Tribunal is not an act, it was in body. Okay, it is a body, fine, just like NCLT. So let's understand how these four used to operate and how Insolvency and Bankruptcy Code came into existence. So before IBC, there were three primary laws. Okay, SICA, Sikh Industrial Companies Act. So it used to have its own board, which is Board for Industrial and Financial Restructuring. This was a quasi-judicial body that used to rehabilitate or inspect these Sikh industries who were financially stressed, okay, who couldn't revive. So either close it down or help it rehabilitate or revive. Okay, so this was the job of BIFR. So the SICA is now repealed. Fine, but the rest two acts, which is the Companies Act and SARFAESI, these two are still there. Where before IBC was introduced, these three were the major laws that were implemented. Okay, so here Companies Act se winding up wala video you can check up. So whatever winding up provisions are there under the Companies Act, that used to come into role when IBC was not there, and SARFAESI was an act that used to play a crucial role. Okay, but for individuals. So the act that has only been repealed after Insolvency and Bankruptcy Code came into existence is SICA, okay, which is repealed now. Fine, but Companies Act and SARFAESI is there with insolvency. Companies Act now deals with other provisions and winding up provisions, obviously. Okay, so discussing first of all two major adjudicating bodies under Insolvency and Bankruptcy Code, that is NCLT and DRT. Okay, that is National Company Law Tribunal and Debt Recovery Tribunal. So National Company Law Tribunal takes up the insolvency application from companies or LLPs only. Simple. And companies and LLPs who approaches NCLT, they approach under IBC. So if a company or LLP or even banks, if they have decided to go to NCLT, then the provisions that will be invoked will always be IBC. But if there is an individual, okay, an individual or partnership formed between two individuals, and so for that, the individual will approach DRT, Debt Recovery Tribunal. So for companies and LLPs, there is NCLT. For individuals, there is DRT. And whenever you approach DRT, the provisions of SARFAESI will apply, not IBC. Okay, so again here bank is given two options. If this is a person who has defaulted, okay, so this person who has defaulted in the payment of loan to the bank, okay, that is, he has taken loan to run a business from the bank, but he has not paid its creditor. So bank here is the financial creditor because it is lending money to the person. Okay, so here either bank can say ki let's do out of court settlement, that is, I'll move to DRT, okay, which will be running as per the SARFAESI का provision क्योंकि individual से deal करता है. So that's why bank can either go out of court and can settle it using SARFAESI's provisions. Okay, we'll start with the SARFAESI and we'll move to DRT. So you just give me the paisa and all, give me the money and all. Or bank can go to court, that is NCLT. So whenever a bank is approaching NCLT, हमेशा IBC provision will be applied. So the whole CIRP process will start. Okay, CIRP process will start where resolution professional will be hired, and then that resolution professional will constitute COC, where resolution plan will be submitted. The entire bankruptcy proceeding will be followed. But if the bank wants to avoid this entire 330 days ka lamba bankruptcy proceeding and want to settle with the individual solely, then they can move to DRT under SARFAESI. NCLT, IBC, DRT, SARFAESI. Companies Act ka winding up, which after the coming of IBC is not required here. So you can look at the winding up ka video for understanding what is winding up provision under Companies Act as well. Okay, this is the entire setup of the acts and bodies working under the Insolvency and Bankruptcy Code. So the objective of the IBC is time-bound resolution of stressed assets, okay, which is giving no returns. Then maximization of value of assets, okay, whatever assets a company has, maximum how much we can derive from it so that you can pay your creditors back and so. Then balancing interest of all the stakeholders of a company who have shares in the company and everything. Fine. Next, promoting entrepreneurship and availability of credit. Okay. Then fifth, changing the debtor-creditor power dynamic. Okay. So basically, ऐसा dynamic we set that the debtor is able to pay the creditors back. Okay, is what's given under IBC. Then the regulator implementing the IBC is Insolvency and Bankruptcy Board of India, IBBI. The separate IBBI board established under the Insolvency and Bankruptcy Code of 2016. This particular body, it does not make law. It only administers or helps in the implementation of whatever laws is given under the code. Okay, implementation is looked upon by this particular body here. Okay. Now, adjudicating authorities under IBC. First is NCLT for companies, and for individuals, it's the DRT, which I have already explained. Fine. So remember, for companies, NCLT, for individuals, DRT. Fine. And there are banks who can seek help of both of these. If the bank does not want to go to the court and start the insolvency proceedings and so on, so bank, if out of the court wants to settle it with the person, with the individual, they can always approach DRT under SARFAESI Act. Okay. And if the bank says ki no, I will require help of the court, and if the bank approaches NCLT, then SARFAESI Act will not come into role, then obviously IBC will. So whenever you are approaching NCLT, remember, Insolvency and Bankruptcy Code ke sections will apply. Whenever you are approaching DRT, SARFAESI Act ke sections will apply. Simple. Now, terms to be used under IBC. So there are multiple terms used in this code which students find confusing. So let's decode those terms. First of all, you'll come across a lot to this term, which is corporate debtor. Corporate debtor is a company or LLP that has failed to repay its debt. Okay, जिसने उधार लिया, who took the loan. Okay, when a company does not pay its loan or dues on time, it becomes the corporate debtor under this code here. Then we have default. What do you mean by default? As the word itself suggests, default means failure to pay money where it becomes due. Your failure to pay the money back to creditor is the default that you are making. Fine. Then we have financial creditor. Who is a financial creditor? So if I am a debtor who took loan, I took loan from someone, so that someone will be my financial creditor. So financial creditor is a person or institution that has given money as a loan. Okay, remember, there are two types of creditors, financial and operational. Financial creditor is someone who gives money as a loan, not goods or services. Okay, this can include banks, NBFCs. Okay, banks are financial creditors. What kind of creditors are banks? They are financial creditors. Bondholders and home buyers after amendment. Okay, so after amendment has been done to Insolvency and Bankruptcy Code, so home buyers and all were also included in this particular financial creditor ka definition. Okay, we'll delve into amendments later on in this video. So for example, if SBI gives a loan to a company, SBI becomes a financial creditor because it lent money, not goods, money. Okay, that's why financial word is used. Then fourth one is the operational creditor, second kind of creditor here. So he is someone, or it is someone who has supplied goods or services to the company. Now a company does not only run on money. Okay, capital to hai, for which financial creditors are there, but a company also requires raw materials, or if you're running a restaurant, you will require vegetables and food to be supplied to you. So you can go to a particular supplier to buy vegetables for your restaurant business and all. So all those goods and services where the person is not lending you money, the person or the institution is lending you goods or services. They supply trucks, transportation to bring those vegetables and raw materials. All these kind of creditors are known as operational creditor, to whom you have not repaid your debt. Okay, and has not been paid. It includes suppliers, employees, vendors, and even the government for unpaid taxes. So if you have not paid tax, every business will have to pay tax to the government. So if you're not paying the taxes to the government is what kind of creditor? The government is also operational creditor, because government आपको पैसा नहीं दे रहा है. Government is not lending you money, but it is allowing you to run a business by providing you services and so on. Okay, giving you proper documentation, या any sort of service, like they are giving you discounts in taxes or whatsoever, जो भी returns and everything, whatever they're doing as a operational creditor here. Fine. Now, financial debt. So financial debt comes from financial creditors. Whatever debt you have taken from financial creditors is your financial debt in simple words here, okay, for the time value of money. Then we have operational debt. Operational debt comes from operational creditors. operational creditors say the goods and services that you have taken and not paid for that. Okay, so that is known as your operational debt. Simple. Now, corporate insolvency resolution process, CIRP, very important. So, CIRP is the legal process started when a company cannot repay its debt. So, when a company cannot repay its debt, CIRP ka process starts, where the company is taking help of NCLT. Okay, judiciary की help, quasi judicial body है, but judiciary की help लेना basically. Fine. So after the case is admitted by the NCLT, a professional takes control of the company because you are not in a condition to run the company anymore. Okay, so here what will happen? You may be the board of directors or whosoever of a company, you're not in a position to run it. So that's why NCLT will hire a professional who will take control of the entire company on your behalf and tries to find a solution ki how we can again run the company nicely and pay off the debts to your financial and operational creditors here. Okay, by selling the company assets for money and so on, whatsoever be the best option for repayment of loans. So now, next is adjudicating authority. So who are the adjudicating authority under IBC? It is the NCLT. For individuals, it is Debt Recovery Tribunal. Okay, so these decides whether to admit or reject insolvency applications or not. Then we have moratorium. What is moratorium? Moratorium is a legal protection period that starts after insolvency is admitted. Once you have been declared insolvent, you approach the court, bankruptcy ka proceeding starts. Bankruptcy is the legal proceedings, the legal process. Insolvency is your financial condition. So I know my financial condition. Now I went to the NCLT on my company's behalf, okay, that I want to start the CIRP, that is legal process pura, bankruptcy proceedings, let's begin it. So here, the moment after insolvency is admitted, whatever legal protection period starts, during this time, no one can sue the company because you have already taken help from the court ki I want the bankruptcy proceeding to start, so no creditor can come and sue you in the court of law because already a proceeding is going on, that is bankruptcy proceeding. Fine. So jab tak your case will run in the NCLT for your company, moratorium period will be there. That is where during this time no one can sue the company, recover money or take away its assets. Next up, we have is insolvency professional IP. So now you know that NCLT hires a professional, okay, who will take over and run your company on your behalf now because you're not in a position. So who is that professional? He is basically insolvency professional who is a licensed expert who manages the insolvency process. He's an expert in insolvency ke dealings, ki how we can find more investors to invest in the company so that they can again run it. Okay, how we can formulate new board of directors and everyone so that the company can run smoothly after this and you can pay off your debts. Fine. So they are registered with the IBBI. Fine. So IBBI helps with the implementation of insolvency proceedings and bankruptcy proceedings and so on. So ये सारे duties होते हैं IBBI के. So they take charge of the company and ensure the process follows the law. Who? The IP. Okay, that is insolvency professional. Then interim resolution professional, IRP. Okay, he was the insolvency professional and this is the IRP. So interim word, as you can say, it means temporary or so. Fine. So the IRP is the first professional appointed after insolvency begins. Okay. So your IP can be IRP in the second stage. Okay. So IP ही IRP बन सकते in the second stage. The same person, but over the time the name changes because the position ka tenure changes and everything. Okay, so the IRP takes control of the company's management, collects claims from creditors. If you are the financial creditor, you are the operational creditor, tell me how much money is due to you. Okay, I'll write or I'll make a list of all the claims. Okay, and forms the committee of creditors. So IP jo hai, insolvency professional, takes the role of IRP so that they can formulate COC, Committee of Creditors. Committee of Creditors comprises of financial creditors only. We'll discuss this also ahead. Fine. Now, IRP kya tha? Interim. That is temporary. Now, that same IRP can turn into RP. That is someone now who will continue to run the company until unless the bankruptcy proceedings are done with. Okay? So, IP becomes IRP. IRP can again become RP. Okay, so resolution professional is either the same person as the IRP or a new person chosen by the creditors only. ठीक है, creditors means all the financial creditors and all, they can either decide कि no, we don't want you to continue as the same RP, but we need someone else, okay, who is an expert again. So IBBI will help with it, and then a new person can also be appointed here. So the RP runs the company during the process and invites plans from investors to revive or restructure the company. What is the main role of RP? Okay, yeah, IRP, yeah, IP, they are basically appointed so that they can invite plans from various investors to invest in the company and help it run again. Okay. Now, committee of creditors. So this IRP, RP and all is formulated. They are appointed because they want to appoint committee of creditors. Okay. So COC is a group of financial creditors, not operational. Okay. Financial creditors have more authority than the operational ones because they have directly lent money to the company. Operational creditors only lends goods and services, but inki authority is more because they are lending money to the company. That's why COC is only formed by financial creditors here. They make major decisions during the insolvency process, such as approving the resolution plan or deciding liquidation. Okay? Their voting power depends on how much money they have lent. So if bank has lent more number of money, of this a lot of money, then the voting power का जो ज़्यादा power रहेगा voting का, that will go with the bank. Simple. Then resolution plan. Resolution plan is a proposal submitted by an investor to save or restructure the company. It may include reducing debt, changing management or selling assets. Okay, जिससे भी you can revive the company. Fine. So a resolution plan बोलते हैं उस proposal को which is submitted by the investor. They all are meeting so that they can ask for a plan from an investor to invest in the company again. So that is known as resolution plan. It is approved by the COC and NCLT. So जो RP होता है, resolution professional, okay, they formulate or they create COC which is formulated by the financial creditors. So approval of this resolution plan mainly vests with the COC and the NCLT. The company continues under new terms after this. Fine. Now, liquidation. Liquidation happens if no resolution plan is approved. After resolution plan is checked into by the COC and the NCLT, जो कि investor ने submit किया था, okay? RP का role है to formulate or create the COC. Now, COC will check the resolution plan submitted by the investor and so on. कोई conclusion नहीं निकला. There's no conclusion. Then that particular point, liquidation will happen. In this stage, the company's assets are sold to repay creditors. After liquidation is complete, the company is dissolved and stops existing. So all the assets are sold, creditors are paid back. After that, nobody is there to run the company again because you have rejected the resolution plan by the investor. There are no investors anymore. So now the company will stop. Next up, we have is how corporate insolvency resolution process works. So let's understand this with the help of an example. So let's understand how corporate insolvency resolution process, okay, when a company turns insolvent, it works. Fine. So starting with ABC Limited, which is a company that we have taken for example. So here if ABC Limited went insolvent, okay, its assets became NPA, non-performing assets, okay. It's facing huge losses. Now it cannot pay back its creditors, financial and operational both. So in this particular case, it will approach the NCLT. Fine. So in this case, it will become corporate debtor, the one who is unable to pay the loan here. Now, ABC defaults with the bank. Bank is one of its financial creditors with whom it has exchanged the loans. Okay, bank is the one that has provided ABC Limited the loan. So bank became the financial creditor here. So the first step is defaults. The company needs to default first, not paying the financial creditor or the operational creditor. Now, not just the bank who is lending money, but there will also be some persons or companies involved that provides goods and services like raw materials and all. So if there is a supplier to whom ABC Limited has not paid any amount, okay, that means operational creditor hai ye, and default has been made to both these kinds of creditors here. So to avoid this situation and to file insolvency application, ABC Limited approached NCLT and became corporate debtor, financial creditor and operational creditor. Okay, insolvency application is filed. So insolvency application can be filed either by the corporate debtor itself or by the financial creditor or by the operational creditor who wants their money back. Fine. So now, once the case has moved to NCLT, CIRP, the entire bankruptcy proceedings start here. Fine. And moratorium period start, which means no one can sue now the company for anything, for selling of the assets or anything, etc. Fine. So now after this CIRP process begins, now IRP or the RP, that is interim resolution professional or resolution professional, is appointed. Okay, who is appointed, who works with the IBBI, the Insolvency Bankruptcy Board of India, who looks upon the implementation of the code. Fine. So IRP can later become RP as well. Fine. And the role of IRP or RP is that it will take the management of the company in its own hands. From ABC Limited के promoters या board of directors से the IRP or RP will take over the management of the company, and then it will form COC, Committee of Creditors, which mainly comprises of financial creditors who are given more preference than operational ones, because they are the ones who lends money directly, okay, not goods or services. So once COC is formed, COC ka role is very important because COC is the one who can even replace the RP, the one who forms it, okay, because IRP is the interim one, okay, temporary one, who can later become a permanent resolution professional who will look upon the management of the company. So if the COC thinks ki no, we need a better RP who can look upon the management, so major decisions are taken by COC more than the RP. Fine. And COC then will invite investors and bidders. Okay, every company will require bidder and all. Like if there are 4 bidders, fine, A, B, C and D, and each of these investors said ki I am going to invest 100 crores, B said I am going to invest 200 crores, C said 1500 crores, D said 2000 crores. So whosoever proposal will look more fascinating, and so okay, who will invest in the company and will again start its operation and will pay off all these 2 creditors, okay, supplier and the bank, and whosoever be the financial creditors here. Fine. So COC will look upon these biddings and these investors and bidders. Okay, so bidders will be there who will bid, and more bidding will be done, and then they will submit a resolution plan to the COC. Okay, resolution plan will be submitted to the COC, and if the COC agrees to it, this is a good resolution plan, everything will be written there. This much we are investing, here we are investing, and this is how we'll grow our company, and then we'll pay you back your money, because COC comprises the financial and creditors only, right? That's why. So they want their money back, for which it's been constituted here. So if it agrees, then the NCLT will approve it. Okay, mainly it's the COC's job to agree with the resolution plan. Then if the NCLT approves it, then the company ABC Limited will again be revived. If the COC rejects the resolution plan, then the NCLT will also reject it, and of course the company will be liquidated. That means all the assets of this company will be sold, and these creditors will be paid who are part of COC only, and then the company will stop working. It will not revive. Okay, so this is how CIRP process works in reality. So see, to sum it up, in step 1, a default is made. That is, for example, minimum default threshold currently is 1 crore. So for any company to be declared as insolvent and the bankruptcy proceeding to get started, minimum default ka threshold which Insolvency and Bankruptcy Code currently provides is 1 crore. So minimum default kam se kam 1 crore ka hona chahiye. 1 crore is the amount. Okay. Then step 2, application to NCLT by financial creditors. So who will file the application to NCLT? How will NCLT know that this company has gone bankrupt and so, or has gone insolvent and so? So it can be financial creditor or operational creditor or corporate debtor itself. So if I run the company, okay, board of directors hai, koi hai, so either they can go themselves as a corporate debtor, or even the financial and operational creditor can also go, because they are the ones who have not been paid for their services or money. Okay, then we have admission and moratorium. So once you have approached the NCLT, so once admitted, once your insolvency application has been admitted by the NCLT, okay, insolvency application. So moratorium under section 14 of the Insolvency and Bankruptcy Code begins. In this moratorium ka period, nobody can sue your company differently or in a new suit. Okay, then no recovery suits can be filed. Recovery suits means no recovery of money ka suit by the creditors can be filed in some other fresh suit in the civil courts and so on. No one can file anything against your company now. No asset ka transfer, no enforcement action because moratorium period starts here. Then we have appointment of resolution professional. Like I explained to you, resolution professional can be the same as the IRP or same as the IP. Okay, so the final person का position that these people get is the RP का position, where RP जैसे ही आ जाता है, board of directors gets suspended. Now you can no longer run the company and your board of directors. Now RP runs the company on your behalf. And what is his job? To appoint COC, okay, to formulate COC and so. That is committee of creditors. Only financial creditors vote under the COC plan, not operational. And operational creditors have limited rights, not many, but very, very limited rights. Okay, so COC is appointed by the RP and so it plays a crucial role in it. Then resolution plan is passed. Once RP has taken over the company, formulated COC, so COC will invite resolution plan from the investors. Okay. Okay, give us a resolution plan that how you want to invest, how much you want to invest, how can we revive the company, what are the strategies and so on. So bidders submit restructuring plans. These investors can be bidders and so, okay, you will require bidding. There can be 10 investors who are coming, I will invest 40 crores, I'll invest 100 crores. So here, the board of directors ki jagah jo RP hai, and then who has appointed COC. So COC is there. Okay, the main committee of creditors, they will decide, of course with limited rights of operational creditors as well, ki who are the bidders who we are approving. Ki if I am a bidder who have said ki no, I'll invest 100 crores, so I'll be given preference over the person who is saying ki I'll invest only 40 crores. Okay, so if I am the bidder who has been accepted, so that bidder submit restructuring plans as well, ki this much we are going to invest. Okay, this what we are going to do ahead to revive the company. And COC and NCLT will have to approve it. Now, seventh step is if approved, company is revived. Who approves it? COC and NCLT, of course. Okay, because NCLT kahin na kahin it will be involved. Because first of all, you went to NCLT only. Okay, NCLT then appoints an RP for you. Okay, who works with the IBBI. So IBBI helps in the implementation programs or implementation thing. Okay, then if rejected, liquidation. So here time limit is very important. Originally 180 days plus extension का time होता था to approve or reject, सब मिला के to approve or reject any resolution plan or so, but later capped at 330 days including litigation. So whatever you are doing, NCLT mein whatever litigation is going on, including your resolution plan submission to COC, then NCLT ka final karna usko, or NCLT whatever the finalization is being done, approval, rejection, every process needs to be completed within 330 days including litigation as of now, current amendment. Okay, now coming at important cases under IBC. So first of all is the Committee of Creditors of SR Steel India ka case versus Satish Kumar Gupta. Very recent and landmark case, of course, of IBC. So in this particular case, SR Steel went insolvent. Okay. So in the insolvency of SR Steel, the Supreme Court upheld that the Committee of Creditors, mainly financial creditors, the Committee of Creditors hote hai, okay, they are the Committee of Creditors, has the power to decide which resolution plan is the best. Okay, by taking up resolution plan from multiple bidders and investors based on its commercial wisdom. Okay, whichever is beneficial for the company. So the apex court reversed an earlier order that had tried to treat financial and operational creditors the same. This is an important case because it gave a clear bifurcation that financial creditors are the ones who lends money, so their authority will always be more than the operational creditors here. Okay, and the Supreme Court said that financial creditors will always have primacy. will be given primacy over the operational creditors. Okay, and it's also clarified that role of section 29A, which bars certain bidders, okay, and reinforced that only eligible applicants can participate in the bidding. This judgment strengthened creditor authority in IBC. Fine. So see, mainly it was held that COC's commercial decision is final. Whatever decision is being taken by COC, who looks upon the resolution plan submitted by the bidders and investors, that will be considered final, and COC will obviously intimate it to the NCLT as well. Okay, and courts have limited interference. Even though I say ki COC and NCLT both will be approving the resolution plan, but COC is the main body who will approve it and then will intimate it to the NCLT, who will have a limited interference compared to COC. Okay, under the code. Simple. So in this particular case, in this insolvency wala case of SR Steel, two bidders were there, main two bidders were there. One is the Numetal and second one was the ArcelorMittal. These two were the bidders who submitted resolution plan to the COC of SR Steel. Okay, out of the resolution plan submitted by these two bidders and investors and companies, okay, whosoever is coming to revive, help it revive. So SR Steel के जो COC थे, they liked the resolution plan, the proposal of ArcelorMittal more. Okay, so ArcelorMittal resolution plan was accepted and then the company approved it and it got revived. Now next case we have is Jet Airways, liquidation after failed resolution plan. So Jet Airways in this case went into insolvency in 2019 under the IBC. Okay, now a resolution plan by the Jalan Kalrock Consortium JKC. He was the bidder या investor who submitted resolution plan to the COC of this company. Okay, was approved by the COC and NCLT both. Okay, both of them approved the plan. Okay, mainly the COC, but the bidder failed to fulfill key conditions. So this bidder, who was the one responsible to bid and then to revive the company, okay, which was approved also, the bidder only failed to fulfill it. Fine. So including making the first tranche payment on time and meeting regulatory requirements for restarting operations. So whatever payment this was supposed to make to the creditors, it didn't make it, and regulatory requirements also were not fulfilled, which was important to restart the operations of the company. कोई license लेना government से, whatsoever be the regulatory requirement, nothing was done. So because of these failures and multiple delays, Supreme Court ordered the airlines liquidation. So even after the resolution plan was approved, still the company underwent liquidation because the bidder didn't work as per its resolution plan. So the company couldn't get revived. Okay, so on 7th of November 24, overturning the NCLAT's earlier approval of the transfer and holding that the plan had failed. So NCLT say appeal can be made to NCLAT, Appellate Tribunal, National Company Law Tribunal, then National Company Law Appellate Tribunal. So even after these appeals and so on, okay, earlier approval, transfer and holding of the plan had failed, okay, overturned this decision of NCLAT, and this effectively ended Jet Airways revival efforts after years of litigation. Fine. So in IBC, if the successful resolution applicant fails to implement the resolution plan as approved, the company can be liquidated even after long legal battles. Fine. This is a very simple case which was passed by the Supreme Court. Ki if the person, the bidder, is only not fulfilling the resolution plan, then how can we revive it? The company will be liquidated even after years of litigation. Then next case we have is MSME exception. Not exactly a case, but what is MSME ka exception? Okay, that is micro, small and mini enterprises and so under the IBC, promoters who led a company into default are generally barred from submitting a resolution plan under section 29A. Section 29A, which we have discussed in that case, which bars certain bidders to bid. Okay, who are those bidders who cannot bid and cannot submit a resolution plan? Any promoter who has defaulted. Who are promoters? The ones who forms the company, the founders of a company. जिन्होंने पहली बार capital raise किया for the company and started it are the promoters. Then after that, board of directors are set up and everything happens. Okay. So if they are defaulting, then in that particular case, they are generally barred from submitting a resolution plan. They cannot be the bidders or investors. Okay. Then, however, for micro, small and medium enterprises, Section 240A provides an exception. Okay, so especially for these kind of enterprises, because they are not very big industries, they have very limited resources. That's why it provides an exception. What is that? This means that promoters of an MSME can submit a resolution plan even if they are ineligible under 29A. So usually a promoter who is a defaulter, who didn't pay back, who didn't even involved in the insolvency proceedings and tried to run away, all these people are barred from submitting resolution plan, because how can we expect them to again revive the company when they are defaulted in the first place? But for MSME, they are given exception. Even if they are barred under Section 29A, still they can. Okay, still they can produce a resolution plan. Fine. The Supreme Court has clarified that as long as the MSME registration exists by the date of submission of the resolution plan, the promoter may use this Section 240A का exception. But remember, the industry should be an MSME. और कैसे पता चलेगा? MSME registration करके एक document होता है which provides the proof that this is an MSME, it's not a big company or industry and so. Fine. Now next, this helps protect small businesses from being liquidated solely because external buyers are not interested. So because these are small industries, so they might not be getting so many bidders just like big companies gets, because it's very small scale industries. So for that reason, sometimes promoters, the ones who have started the company, they only brings in to the table a good resolution plan to revive the company. Okay, let's do this and that and so on. So in that case, so that these industries should not directly be liquidated, that's why this exception is being given to MSME. And 240A relaxes Section 29A for MSMEs, allowing defaulting promoters to be a resolution applicants to produce resolution plan. Simple. Now next case we have is Swiss Ribbons versus Union of India 2019's case. So this case is also pretty much easy. It talked about the constitutional validity of the insolvency and bankruptcy code. This entire code was challenged on the ground that it unfairly discriminates between financial and operational creditors, because COC mainly comprises and gives more voting rights to financial creditors, not operational, as you all know now. Okay. So the petitioners also questioned Section 29A, disqualification of certain promoters who are defaulting. Okay, so 29A को भी challenge किया गया and the act also. Then, and Section 12A was also challenged from this particular code, withdrawal of CIRP with 90% COC approval. That is, if 90% of the COC approval is given to withdraw of CIRP, then it is withdrawn. So too much of excessive power is given to the COC, which mainly comprises of financial creditors, was the major concern in this case. Okay. Alleging violation of Article 14 of the Constitution. So Supreme Court, what the Supreme Court stated, ki no, IBC is constitutional and upheld the entire code in entirety. That is, the main objective of the code is resolution and revival of the corporate debtor and its company, and liquidation under Section 33 is only a last resort. Okay, Section 33 mein liquidation is the last resort if we cannot reach to any conclusion or approval of a resolution plan. Fine. So the court ruled that the distinction between financial creditors and operational creditors, okay, 5 clause 8, 5 clause 21, is reasonable because financial creditors are better equipped to access viability, because they are the ones who have more knowledge of these things compared to operational ones, who can be any lender of goods and services. So now it also upheld Section 29A and 12A as constitutional. Why? Because IBC is a beneficial economic legislation aimed at timely resolution and maximization of asset value. So it's okay if we are giving more importance to financial creditors here. Fine. Now coming at our fifth case, Innovative Industries versus ICICI Bank of 2017. Listen to these landmark cases very nicely. This will help you clear the concept of insolvency and will also help you in multiple exams if questions comes like this. So in this case, the Supreme Court judges, okay, the justices, delivered a detailed ruling marking a paradigm shift under the code. That is, the court clarified that IBC is a complete and exhaustive code in itself, aimed at time bound insolvency resolution. What is a time bound resolution? 330 days currently. Okay, triggered upon default. Default is the first stage that we've already discussed, that how CIRP process starts. Okay, so that bankruptcy proceeding ka naam hai CIRP. Fine. Now, meaning non-payment of a due debt, even if disputed, provided it is payable in law. Now, it distinguished financial and operational creditors under Section 7, that a financial creditor can initiate CIRP upon proof of default without concern for disputes, whereas under Section 9, an operational creditor must first issue a demand notice and cannot proceed if a pre-existing dispute exists. So we know who can file for insolvency application in NCLT, either financial creditor or operational creditor or the corporate debtor. Okay, as we have studied. But here also financial creditors are given more power compared to operational creditor to file for insolvency application once the company makes default. Okay, so that is here under Section 7, financial creditor can initiate CIRP, okay, without concern for any dispute. But under Section 9, operational creditor requires a demand notice, okay, and cannot proceed if any pre-existing dispute exists within amongst themselves or with the company or whatsoever. Okay, otherwise financial creditor can do it anytime, can go to the NCLT and file for CIRP or insolvency application anytime. Then once admitted, management vests in the interim resolution professional and the directors cannot maintain appeals on behalf of the company. Again, very easy point here, that once the insolvency application is admitted, CIRP process begins, moratorium start ho jata hai, and with that the interim resolution professional, who later becomes the RP as well, resolution professional, they take over the company from the board of directors or from the person who runs the company. Okay, this is what is given under this case as well. Then finally it was held, court emphasized strict timelines, 180 days extendable by 90 days, creditor control through the committee of creditors, and binding nature of an approved resolution plan. It is binding in nature. So 180 days is the standard timeline. Okay, then one time extension is 90 days ka, and then mandatory limit again इसमें add हो जाएगा and it will become 330 days in total. Okay, if in 330 days we arrive to no conclusion, then the company is liquidated. Okay, its assets are sold off and then the creditors are paid back and then the company stops working. Now coming at major amendments to IBC since 2016. So as it came into existence in 2016, after that it has undergone multiple amendments. So let's dive into some crucial ones. First one is the 2017 ka amendment. Section 29A that talked about bar to certain bidders like defaulting promoters and all. So that was introduced under this particular amendment. Okay, this amendment introduced 29A. It said that promoters who defaulted on loans, okay, the ones who have defaulted because they are the founder of the company, okay, who first raised capital and started the company for first time, or whose accounts became NPAs because they are in the losses. Now they cannot pay back anyone, so their account will be declared as non-performing assets. Okay, cannot bid for or regain control of their company during insolvency. MSME mein it's an exception, but usually they cannot become the bidder to revive the company again because they have defaulted in the first place. Fine. Now purpose. Earlier, some promoters would allow the company to go into insolvency and then buy it back at a lower value. Why this provision is introduced? Because promoters started misusing this thing. Ki fake insolvency will show, okay, to the NCLT and then we'll buy it back at a lower value. Fine. So this amendment stopped such backdoor entry of defaulting promoters. Okay. So if you are faking that your company has gone insolvent and then buy it back at a lower value, fine. So in that particular case, this is wrong with other stakeholders and shareholders as well. So to avoid this, this particular section has been brought. But what does this line exactly means? This why promoters used to do, because once you enter into insolvency and you go to the NCLT and all the CIRP process conducts and everything happens, so your loans will be forgiven. Okay, आपका पूरा loan माफ हो जाएगा because you have faked that you have become insolvent. You cannot pay back your creditors, so your debts will be settled. Okay, it will be cancelled, and now those promoters who have faked insolvency, they'll again get back their same company at a lower price. Okay, they'll buy it at a lower price, and all their debts, that they have taken from the financial and operational creditors, that will be forgiven, because from the insolvency process, from the bankruptcy process, new bidders that they have got, okay, they have invested the money, they have paid the creditors already. Now these promoters also becomes one of the bidders and they buy it at a lower price. So sare debts maaf ho gaye and then they got the company back. So that's why, to avoid this thing, this section has been introduced. Okay, now insolvency and bankruptcy code ordinance amendment aaya tha 2018. This was a major reform. Why? Because home buyers were recognized as financial creditors. They were given financial creditor ka status. Okay, home buyers, the ones who buy the homes, yeah, houses and plots from the builders and so money paid by home buyers to builders was treated as financial debt. Okay, because what if a builder defaults? Home buyer ka to loss, and it will be a loss for them. So home buyers were given voting rights in the COC to approve a resolution plan. So the impact was that real estate buyers got legal protection and participation in the insolvency. Okay, so if a builder, jisko you have made some advance payment, if for example, if they are building a society, okay, you have paid certain amount to book a flat in that particular building, but then the builder says ki I have gone insolvent, my construction company has gone insolvent. Now what you will do? So you are the home buyer here, okay, your right needs to be protected. So for that reason, in this amendment, you have been made a financial creditor, where you will be the one who will be member of COC. So your debt will be cleared first, when the COC will invite resolution plans from multiple bidders out there who will bid ki okay, we are taking over a construction company, we'll finish up the flats and everything by investing this money, and we'll first of all pay off the creditors here. Okay, so home buyers' rights were protected under this. Now, Section 29AK relaxations, the amendment clarified in this 2018 only, amendment clarified when NPA disqualification would apply. That is, it also gave a limited grace period to resolution applicants in certain cases. This ensured that genuine bidders were not unfairly disqualified. So, some grace period to resolution applicants who are filing the resolution plan. Okay, the bidders who are filing resolution plan to again revive the company. So in certain cases, thoda sa grace period we can give them, so that immediately unfairly they don't get disqualified here because of the non-performing assets. Okay, 29A mein kya tha? Promoters, defaulting promoters will not be considered as bidders, but relaxations were given ki even if you have non-performing assets, you are a promoter who have defaulted in your loans, because of which you have turned insolvent, still we are giving you some grace period to think of a good resolution plan and present it before the COC. Okay. Now, MSME exemption, as we have discussed already, this was also a part of this particular amendment only. Fine. Then withdrawal of CIRP section 12A, which was challenged in that case. So this also came from this particular amendment only. So insolvency proceedings can now be withdrawn if 90% of COC approves. Okay. If 90% of COC says ki no, we don't want to continue this resolution plan ka discussion and everything, CIRP in general as a whole, so it will be dissolved. So earlier, once the process started, it was difficult to stop, but now if 90% of COC wants to withdraw, then it will be withdrawn, and then the company will go to liquidation and so. Fine. Now, reduced voting threshold. Earlier, major decisions required 75% voting approval to approve a resolution plan. Now, major decisions require 66%, routine decisions require 51% to make decision making faster. Okay, कितने लोगों ने हाँ बोल दिया? Okay, let's just approve it and so. Next, we have is Limitation Act applicable. It was clarified that the Limitation Act applies to IBC proceedings as well. So this means old and time-barred claims cannot be revived through IBC. Now next, Insolvency and Bankruptcy Code का second amendment after 2018. 2018 में again second amendment was made to the same. Okay, so further clarified the position of home buyers. So home buyers के लिए provision was already introduced in the same year's amendment. So a second amendment was passed which improved and clarified the position of home buyers even more and strengthened procedural clarity in insolvency proceedings here. Okay. So first of all, now coming at 2019's amendment. So this particular amendment is very important. It introduced 330-day outer limit, which we have been discussing all this time. So corporate insolvency resolution process must be completed within 330 days, including litigation time, or else the company will be liquidated or dissolved. Fine. Now, section 31 ka clarification. Once a resolution plan is approved, it becomes binding on the central government, state government, local authorities. This prevents government departments from raising old claims after approval. That is, it is given a binding status. Okay, and all these things needs to be completed within this 330-day time period. Now, third clarification brought by second amendment of the same year is strengthening operational creditors' position. Too much of powers were given to the financial creditors only. So some procedural safeguards were added to ensure fair treatment of operational creditors as well. They have limited rights, but they have certain rights in the COC as well. Now, next up is 2020 ka amendment. So here, suspension during COVID. So when COVID hit our country, so at that time, defaults arising between 25th March 2020 to 21 could not trigger insolvency proceedings because everything was closed. This situation was something that companies couldn't have helped. A lot of companies went into losses. Okay, so that every company does not go to the insolvency proceedings and everything. So that's why from this period to this period, any default arising where the company failed to pay back its creditors and all the creditors cannot move to the court to start any kind of proceeding against them, even insolvency. Okay, this help was given to these companies between the COVID time because it's very hard time that time. Okay, so section 10A was introduced for this purpose. For this purpose only the section was introduced to protect businesses affected by the pandemic. Okay, so that no creditor can go and file for proceedings because you haven't paid it. Now, very important 2021 ka amendment. This particular amendment brought pre-packaged insolvency resolution process PPIRP for MSMEs. Okay, for MSME, CIRP is usual process. For all other companies, for MSME, this is the name given. Okay, a faster and less disruptive process was introduced for MSMEs. So this particular amendment is very crucial for this small and medium enterprises. So its features were debtor remains in control of management. 29A ka exception is already there for MSME. Ki even the defaulting promoters can become the bidders and can submit resolution plan and revive the company. So debtor remains in control. Okay, resolution professional की जरूरत भी नहीं पड़ेगी because now debtor can remain in control of management as well. 29A तो was already there where they can become the bidder. But as you know that normally a resolution professional takes over the control of the company from the promoters and board of directors. But as per this particular amendment act, debtor, the promoters can also remain in control of the management. RP ka role will also be omitted from here because MSME is a small startup. Okay. Now creditors supervise the process. Creditor will supervise the process, but instead of RP, debtor can remain in control of the management. Purpose to allow quicker and more practical resolution for small businesses because they are the promoters of the small business. They will personally take more interest in reviving it. Okay, other people, other bidders will not have that much interest because it's a small scale industry. Now, ongoing regulatory amendments. Okay, ongoing ones. So, the Insolvency Board of India, IBBI, regularly updates regulations. Okay, like more than 120 amendments have been made relating to information utilities, valuation standards, liquidation process, avoidance transactions, fast track CIRP, cross border insolvency. So these changes aim to make the insolvency system more efficient and practical. Small regulations the implementation body keeps on making. Okay, but the primary amendments we have already discussed. Okay. Now, key structural changes in debtor-creditor relationship. So, before IBC, debtor was in control. After IBC, creditor is in control because RP takes over the management of the company and COC approves the resolution plan. Okay, who is formed by the financial creditors mainly. Okay, of course, for MSME, debtor is still in control, but usually, apart from MSMEs who are the exceptions, usually creditor is in control after the implementation of IBC. shift from borrower friendly to credit discipline regime, and promoters risk losing company upon default. Okay, now let me conclude the entire concept with the help of an example. Imagine a restaurant chain borrows 20 crores and business fails. Okay, bank file CIRP. Okay, restaurant business borrowed 20 crore from bank but it failed. Now under IBC, what could have happened? Management suspended, RP takes over, who is previously IRP and then IP. Okay, they can be the same persons. Then professional runs company, that is RP. Investors bid, okay, and submits resolution plan. Okay, resolution plan to COC. Okay, RP has the role in formulating COC, which is mainly the financial creditors and thodi bahut operational creditors as well. Okay, then either revived or liquidated. If the resolution plan is approved by COC and then NCLT as well, then it is revived. If not, it is liquidated. Okay, payment ho gaya and then it is dissolved. Okay, so this is the entire insolvency and resolution process.